So hi guys, I thought we'd take a quick look at the never filed, the unfiled Supreme Court lawsuit that Mike Lindell said he was going to file, that he was going to get a plaintiff. As you can see, the plaintiff is the state of Insert Your State, which of course isn't a state, and he promised. I mean, he said upwards of nine at one point. He could get upwards of 9 states to sign on to this, and ended up getting 0, and that's why we've got this essentially unsigned copy, unfiled copy more importantly, that he's published, and we can now, I mean, I'm not a lawyer or an American, but we, given the seriousness or the lack of seriousness of this complaint, we can basically sort of point at it and make fun of it, and that's a level we're aiming for here. We're not aiming for any sort of serious legal analysis. I think the first thing that I think is absolutely the most important is what is not in there. Is if I use Control F, China. He's been making allegations for, I guess, about 8 months, if not 9 months, that China hacked the election. He's probably said it hundreds of times. So, but he's not suing China. So let's just have a quick look. See, this isn't about China hacking the election. This is sort of vaguely saying countries, and I quote, such as China, Russian, not Russia, China, Russian, Iran, and Venezuela, that they have, you know, the same capability to hack the election. But if we go back to the start, notice who the defendants are. None of these are China, none of these are agents of China. They are the United States, President, Vice President, Attorney General, Speaker, and President pro temp of the Senate, as well as 5 of the swing states. My take on this is it's just rather sad, to be honest. You can scroll, we've got a good useful table of contents, and it really, if we read this part sort of here, it really, and it goes on here, all of this page really, I don't even need to highlight it, just all of the page. It tells us what this lawsuit is going to be about. So I'm thankful that they got that bit right and got the table of contents in there. But it's essentially claims that were dismissed a year ago, that the Texas versus Pennsylvania lawsuit was on this subject, and it failed miserably. Leave to file was denied because Texas hadn't demonstrated a judicially cognizable interest in sister states elections. For some reason, all the talking he's done about China stole the election, China hacked the election, is he's going for claims that were dismissed by the courts in, I don't know, 30 or 40 cases, and trying to relitigate them a year later. Truthfully, I think it's pathetic. It's sad. No state, I believe, could sign on to this. That it's just too useless, really. It would, if any state signed on to this and it ended up going to the Supreme Court, it'd be demeaning to all those involved. It'd be demeaning to the plaintiff, the defendants, and the courts. I think this is where it's worth starting. Did defendant states violate the Electors Clause or the Due Process Clause of the 14th Amendment by taking or by allowing non-legislative actions to change election rules that would govern the November 2020 election? Well, this has been litigated to death. This is kind of how sad, and I think that is the right word, this is how sad this is. And it was litigated to death a year ago. Did the federal defendants violate the Guarantee Clause or the Take Care Clause by failing to pursue claims against defendant states for their constitutional violations described above, etc.? I mean, you could say many things about that. I mean, apart from the answer is just no, because there wasn't a meritorious lawsuit to be had. The next thing I would add is, you know, who was the president back then? Who was the president of the United States in 2020? In November 2020, it was Donald Trump. and he actually did. He did join a lawsuit. He tried to join the Texas versus Pennsylvania lawsuit that would have that addressed all these supposed violations. So it's not true that. So it's kind of bizarre in that sense that in effect that they do address this later on. In effect, he's blaming Donald Trump and Mike Pence for this. So I'm skipping bits here because of, you see, it's at the top 82 pages, and also because in parts it's just reproducing the content of lawsuits that failed a year ago. But this bit, when I first read it, this bit killed me. This is like, the action is timely. It's been a year. It's been more than a year. It's been almost 13 months now, and they're apparently with a straight face trying to argue that the action is timely. The action is not timely. I mean, like, this lawsuit or something pretty similar to it failed a year ago, when at least hypothetically the court could have given them what they were asking for. I'm just going to be using this as an example of why I'm skipping so much. The uncontrolled use of mail-in ballots in 2020 made widespread election fraud inevitable. I mean, how old a claim, how, dead, uninteresting do you want to get? I mean, now this is interesting in that Professor J. Alex Haldeman has come out on Twitter to say that while he does believe security flaws aren't being addressed, there's no credible evidence that the 2020 election was hacked. So obviously there's a difference between it's possible to hack something and something was hacked. Again, we arrive on page 23. So the electors clause is the one in Article 2 of the Constitution about how presidential electors are selected in a manner such as the legislature thereof may direct. That's either the wording or very close to it. Again, these are very old claims. There's no reason to read them. You can find these claims in lawsuits from this time last year and just read them yourself that way. This, however, I mean, false. It's a lie. You can't. There's really no other way of saying it. This is not true. Found outcome determinative number of unlawful votes. That's not true. They didn't find a single unlawful vote. So that bit is not true. That's a lie. And we've kind of been through this as well separately. The analysis on this is he's just wrong, and he hadn't understood the process, or he was deliberately lying. I mean, he's quite an intelligent man, which makes me think he was probably deliberately lying, that this is not true. He was given the job of analysing envelopes, not ballots. And there are cases where an early ballot gets sent back to the voter because there's time. When there's a mistake on the ballot, there's time to send it back to the voter and have them correct the error and then send it back again. Now, both of the envelopes that voter uses to vote, they're both kept and they're both signed, so you end up with more than one envelope but only one vote. And sorry, I have to go back and find this because I forgot. So there's a law that requires, voters to submit their registration at a given point. Such deadlines are permissible. The state is certainly justified in imposing some reasonable cut-off point for registration. Fine. Let me get this. A federal district court violated the electors clause. I mean, what to say about that for a start? Also, it just says a deadline, or some reasonable cutoff. Sorry, imposing some reasonable cutoff. It doesn't say anything that you can't change the cutoff. There's nothing in that case that says that. Then we get, let's say a lot of this material is very repetitive, so I'm deliberately dropping it. But they've just, Pennsylvania's final results show 49,141 more votes than voters. No, they don't. I had a look. Pennsylvania has about 9 million, or had at the time, 9 million registered voters. 7 million of those, slightly under, voted. So how is that more votes than voters? There's 2 million less votes than voters, but they're just making this up. I mean, what's the source for this? So I'm going to scroll down a little bit. No, onto another section. I don't understand what their source is. That leaves the fact that there are at least 49,141 more confirmed votes than voters. But where's the source? I don't see one. And then, having read this before, we get to the claims. Count 1 electors clause. This is the bit, so we've got 5 or maybe 6 pages left. This is the bit where you can sort of start reading the whole thing without having to skip and edit. Non-legislative actors lack authority to amend or nullify election statutes. I mean, it's more complicated than that, because legislatures, they don't do everything themselves. You don't have to have the representatives and the senators counting every vote themselves. They delegate authority through statutes to the secretaries of state, and that's, they did that in 2016 when Trump won. And they're just more or less just assuming that this, I mean, why does this violate the electors clause? This violates the electors clause, is what they're saying. But it's just a legal conclusion as far as I can tell. There's no A to B to C, so why does this violate the electors clause? Count 2, due process. I do pronounce it due process, even though it's process in the UK. Again, how, just seems like a conclusion. They're just saying, look, this thing never got filed anyway, and it never will. But to allow invalid ballots to be counted and valid ballots not to be counted, what have they even talked about? They've talked about the supposedly invalid mail-in ballots, but where have they talked about valid ballots not being counted with express intent to favour their candidate for president? Their candidate. So, did states with a Republican governor favour Biden for president because they're saying, their candidate? The guarantee clause, they do actually tell us what it is in fairness. They shall guarantee a Republican form of government. I mean, we have a Republican form of government. I mean, whatever you think of Biden, he hasn't reinstated the monarchy, has he? Now, so they do mention Texas versus Pennsylvania. The United States has parens patriae standing to challenge the manner in which states conduct their elections. I mean, basically, and it explains it here, the failure to pursue the United States' meritorious claim violates the guarantee clause. Again, that's just a conclusion as far as I can see. They're not saying how it violates, how does it violate the guarantee clause. This is also something where, the courts have said, the Supreme Court has recently, as 2019 has said, you can't sue for the guarantee clause. I mean, the take care clause is something similar. It says the president shall take, I'll highlight, the president shall take care that the laws be faithfully executed. Again, I mean, the first thing to say is Biden wasn't the president, so he's really suing Biden or Biden and Harris here, or he would be suing if he'd managed to get it filed, saying that they didn't try and annul their own, they didn't go to court to try and annul their own election victory. That's what he's saying. And as we know, we see above, they had a meritorious, in his own words, claim. I mean, they don't. This is nonsense. So prayer for relief is what are they asking the court to do, basically, which is what it says here. Issue the following relief. In other words, this is what we want you, the court, to do. So that's not going to happen, I mean, it's not been filed anyway, but even if it were, not going to happen. Also, not going to happen. The certification of the election results on or about December 14th. Well, the Electoral College, which is not a thing so much as it's the electors in every state separately, they did meet on December 14th. The certification was earlier, though it varies. And vacate those certifications. Well, the person who wins the election isn't the person with the most certifications anyway. It's the person with the most Electoral College votes, although they do get to that in fairness. Again, the United States violated the guarantee clause. Again, by allowing the November 2020 election to proceed on the basis of unconstitutional results in defendant states. Well, that can't be Joe Biden, of course, because he definitely wasn't the president in November 2020. So next one is that they failed to act to remedy the violations. Well, apart from the fact, if we just pretend for a second that there are some violations, which there aren't, what could they do about it? You can't, no backseas. You can't undo the results. Although we're getting to that with number 7. Enjoin the use of vacated certifications. So this is assuming number 7 that they are going to vacate the certifications in the first place, because obviously the court doesn't do that. This means nothing. In defendant states' use of the 2020 election results for the office of president to appoint presidential electors to the Electoral College. So no mention of the vice president here. So they're not trying to get rid of Kamala Harris by the looks of it. I mean, enjoined is also a problem with time, in that This is something that's already happened. You can't issue an injunction against someone to stop them doing something. It has to be something that's prospective or current. You can't stop someone from doing something that they've already done. It's, you know, the equivalent of trying to stop a woman from giving birth to a baby she gave birth to 6 months ago. That's sort of what they're asking for there. Number 8. And vacate that count, I think, is the key part of this. So declare that it violated these and vacate that count. Enjoin, again, as far as I know, you can't use the word enjoin this way. It means compel, or they mean what they want to say is compel the Office of Defendants convene special sessions, which again, I'm sure that's not something they can do anyway. To vote for the President and Vice President respectively pursuant to the 12th Amendment. Well, the 12th Amendment, I don't have the text right in front of me, says that if anyone gets a majority of the whole number of electors, the number of electors is 538, which is why you need 270 to win. Biden got 306, which is more than half. So what actually happens is that the procedure that kicks in is 1 vote per state if nobody gets a majority, but someone has. So this, I can see what they're asking, but they're asking basically to pretend that never happened. And they said, oh, by the way, we'll go 1 vote per state and find out. I mean, I'd have to double check. I think probably Biden would still win if we went, because the Democrats control Congress. There are some small states, so they have less representatives to Republicans. There are some small states, since it's 1 vote per state, not per representative. There are some of the smaller states that have Republican representation, like Wyoming. So they could possibly win on that basis, but I'd have to sit there and work it out. And so I think Joe Biden would still win that. Authorize the defendant states to conduct a special election to appoint presidential electors. Well, I mean, clearly that's not can't possibly happen. Just so many reasons. I'm not even going to start talking about it. Alternatively, authorize pursuant to the court's remedial authority the defendant states to conduct an audit. Yeah. I mean, it wouldn't even help them, because it wouldn't fix their injury if they're claiming that their injury is that the wrong person won, which is absolutely what they're claiming. I mean, nowhere actually in this, so let's just read number 12, forget 13 and 14. Basically, they're saying stop the states, number 12, and join defendant states. Use the word enjoin correctly, let's give them some credit. From breaking what they view as breaking the law. Which is not normally something you can do, is to get a court to issue an injunction against them, to tell them not to break the law, because the law basically is assumed or it does that. So what they're actually not doing here is asking the court to reinstate Trump as president, which, given the claims they've made, you think they might ask. I mean, obviously they're not. I mean, this will never get filed, and they won't get leave to file. If it were, it'll be a leave to file is denied. But if it were, like, you might as well just go the whole hog and ask them, say, make Trump the president. So my take on this is that it's just boring, mostly. There are a few bits that are quite funny, but this is year-old material. Even they pointed out that, you know, Texas versus Pennsylvania. This case, or a very similar case, got dismissed a year ago. And that's it really. It's a poor effort. It's a weak effort, and it's frankly boring, is what it is.